All right, everybody. Hello, this is Bob Probst with the Probst Law Firm again. It's another Wednesday. It's 4 o'clock, and it's time for another live Facebook talking about different portions of the law that may be of interest to you. As you may recall, last week that we went over DWI law in general in North Carolina. We kind of went through the parts of what's the standards for pulling you over, what's the standard for investigating a driving while impaired, what's the standard for arresting for driving while impaired, sort of what the arrest procedure is, and then a little bit about the trial procedure. But this week, what I want to go over is what punishment you can receive in North Carolina if you are either convicted of driving while impaired or if you are found guilty of driving while impaired after you have a trial. Now, as I told you last week, North Carolina takes driving while impaired very seriously, convictions very seriously, and their punishments reflect that. And the punishments have been decided by the North Carolina legislature in weighing different factors that I'm going to go into to determine what punishment you should get if you either plead guilty or are convicted of driving while impaired. So the way this works is after you enter a plea of guilty or you have a trial and you're convicted, there's what's called a sentencing hearing. And it happens right after the trial is over with or right after the entry of plea. And at the sentencing hearing, a judge will listen to evidence and decide what punishment you will get. And the judge will enforce that punishment right then, right there, before you leave the courtroom, either by the front door going out the way you came in or by the back door going to the jail. So I'd also remember last week I told you that I will tell you, and I'll do it before the end of this segment, I will tell you the one thing you can do to make absolutely sure you don't have to have an active sentence if this is your first DWI conviction. Or conversely, I'll tell you the one thing that if it occurred in your case, even though it's your first driving while impaired conviction, you will have to serve an active sentence in jail. And when I tell people this, when we're out to dinner or at somebody's house or at a party or whatever, it kind of blows their mind. So I'm going to save that for the end. So stick with me till the end here, and I'm going to tell you what you should absolutely make sure does not happen in your case. If, even with your first offense, you want to make sure you don't spend at least 7 nights in the county jail for wherever it is your case is being held. So let's say we're in the sentencing hearing now. What the judge has to decide to determine which punishment you get or what grossly aggravating factors, what aggravating factors, and what mitigating factors apply to your case. The grossly aggravating, the aggravating, and the mitigating factors are factors that the North Carolina legislature has listed in statutes that if they apply to your case, it'll determine what level of punishment you're at or what level of punishment you'll be sentenced in. So it's very important to make sure only the appropriate factors are applied to your case. And that's one of the reasons you probably want to hire an attorney for DWIs, because your attorney will make sure that the court only considers the factors that the attorney believes are appropriate for your case. So the grossly aggravating factors and the aggravating factors are going to be presented by the district attorney trying your case. So the burden's on them to show the grossly aggravating and the aggravating factors. Then you or your lawyer has a chance to show mitigating factors. Obviously, just by the names, you can tell the grossly aggravating and the aggravating factors are meant to enhance punishment, and the mitigating factors are meant to lessen the punishment. So let's go through the grossly aggravating factors first. They're the worst factors. They're the factors that's going to really put you in trouble if any of those apply to your case. And there aren't that many of them. And with all the factors, I'll go through, if not all of them, just mostly the ones that apply in most cases. So a couple of grossly aggravating factors that will apply in your case is if you have had a prior driving while impaired conviction, within the last 7 years from the date of this conviction. So if you're convicted on August 5th of 2020, if you've had a conviction since August 5th of 2013, that's going to be counted as a grossly aggravating factor. And it doesn't matter if that conviction is in North Carolina or some other state, it will apply. Another grossly aggravating factor is if at the time you were driving the vehicle for this conviction, your license was still revoked for a prior DWI. Now, I've seen cases where the prior DWI is more than 7 years ago, but the person never did what they needed to do to get their license back. So their license was still revoked for that prior DWI that might have been 10 years ago. And so that aggravating factor applies to their case. A really big one, aggravating factor that would apply to your case is if you're driving, at the time you're driving that you get convicted of this driving while impaired, you have someone under the age of 18 in the car at that time. Another aggravating factor is you have somebody over the age of 18, but their mental capacity is under the age of 18 in the car at the time that you're driving. Or a final one is if you have somebody in the car at the time you're driving who's physically impaired and can't get out of the vehicle without having assistance, then that will be considered a grossly aggravating factor. So those are the typical grossly aggravating factors that the district attorney may try to say applies in your case. And to be honest, the majority of them are prior conviction in the last 7 years, driving while license revoked for a prior conviction of impaired driving, or having someone under the age of 18 in the car. The next set of factors that the district attorney may try to apply to your case are what are called the aggravating factors. And there's more of those. But again, the district attorney would look at the case and decide whether they want to argue to the court that any of these factors apply and should enhance your punishment. One of those, if you blow a 0.15 or higher, that's an aggravating factor. A second aggravating factor for DWI in North Carolina is if you've had a prior conviction for driving while impaired, but it's been more than 7 years ago. So if you're convicted August 5th, 2020, but you have a prior conviction in July of 2010, that will be an aggravating factor, not a grossly aggravating factor. If your driving while license is revoked at the time you get this conviction for not an impaired driving, just for some other reason, that's an aggravating factor. If you're convicted of speeding to elude arrest at the time you were driving, so they try to pull you over and you take off and you try to elude the arrest, that's going to be an aggravating factor. Or if you're convicted for speeding more than 30 miles per hour at the time that you were also driving while impaired, that's going to be an aggravating factor. And then if the court determines that whatever driving that the officer reports you were doing was, quote, especially reckless, that's an aggravating factor. And that definition, that term isn't necessarily defined. It's just on a case-by-case basis. So the main aggravating factors that the court will consider is if you've had a DWI more than 7 years ago, your driving while license revoked at the time of this case for something other than impaired driving, you blow a 0.15 or higher at the time of this case, if you have an accident causing personal injury at the time of this case, or if you passed a stop school bus at the time of this case. So those are mostly the aggravating factors. And in the sentencing hearing, when the DA gets done offering to the court what they contend are aggravating and grossly aggravating factors, you or your attorney, one, gets to argue that one or more of those shouldn't be considered as grossly aggravating or shouldn't be considered in this case. But more importantly, and most often, you or your attorney is going to offer the mitigating factors. And that's the factors that the court can take into consideration to lessen the punishment for what you're going to get. Mitigating factors are things like, the first mitigating factor is if your breathalyzer, your blow in this case, is 0.09 or lower, that would be considered a mitigating factor. If you have a safe driving record. And you have to look at the statute for that. It really depends on what kind of prior tickets you've had. But if you've got a safe driving record as defined, that's going to be a mitigating factor. If prior to your conviction, you go and get an assessment, an alcohol assessment done by a certified agency, and they give you the information about that, and you turn that into the court, that's going to be a mitigating factor. And that's another reason for you to have an attorney help you, is because they can get you to the place to get your assessment, so you can use that as a mitigating factor. You're going to learn later that if you don't get it before trial, the court's going to order you to get it after the trial or after the conviction, and then it can't be used as a mitigating factor. So you might as well get it before trial so that you can use it to your advantage. And then any other factors that the court deems appropriate that mitigate the situation. But the three big ones are: you have a 0.09 or lower on your breathalyzer, you get a pretrial assessment done, or that you have a safe driving record. So what happens is the DA talks about the gross aggravating factors and the aggravating factors, and you or your attorney talk about the mitigating factors. And then the judge has to take all that into consideration and weigh them against one another, and then decide what factors to apply and then how much weight to give to each one of those factors. And depending on how the judge does that is going to determine what level you are punished in. So there are basically six levels in North Carolina for you to be punished in. It's level 5, 4, 3, 2, 1, and A1, or aggravated 1. Level 5 is always the best level for the defendant, and level A1 is always the worst level for the defendant. So you want to try to offer as many mitigating factors and combat as many aggravating or grossly aggravating factors as you can to keep you in that 5 level, or the 4 level, or the very worst, the 3 level. Because 3, 4, and 5, you can get a suspended sentence. A1, 1, and 2, you must serve an active sentence even if it's your first offense. So let's go through a little bit about the levels that we have, and we're going to start with level 5. So level 5, a judge will make a determination that after he hears all the statutory factors, that the mitigating factors outweigh the aggravating factors. So the mitigating factors are more important, or maybe there's more of them than there are aggravating or factors. So he or she's going to sentence you as a level 5. That's a fine. Level 5 can get you a fine up to $200, jail sentence from 24 hours to 120 days. Most of the time, those jail sentences are suspended, but as part of the suspension of the jail sentence, you either have to do one of two things. 1, serve 24 hours in jail, or 2, you can agree to do 24 hours of community service. If you do the 24 hours of community service, you don't have to serve the 24 hours in jail. If you get a suspended sentence, then you can be placed on unsupervised probation or supervised probation, and you're going to be required to get that alcohol assessment and follow the recommendations that I spoke about earlier. You should get before trial or before your plea, but if you don't, even in level 5, the judge is going to make you go get it and follow through with the recommendations. That's mostly level 5. Level 4 punishment in North Carolina is the next best level for the defendant. And that's typically when the aggravating factors that the court considered and the mitigating factors that the court considered just cancel each other out. Neither one outweighs the other. They're just even, and they cancel each other out. So in that case, the judge might sentence you as a level 4 offender. And then as a level 4 offender, you can get, again, a $500 fine, 48 hours in jail, up to a maximum of 120 days in jail. But again, that's most likely going to get suspended. And if it does, you're going to get a choice of spending 48 hours in the county jail or agreeing to do 48 hours of community service. If you agree to do the 48 hours of community services, you don't have to go to jail. Once your sentence is suspended and you're placed on probation again, you will have to get an assessment done, just like you would have done with pretrial, and follow through with those recommendations. Pay your fines and do your community service. The next level down for punishment is level 3 punishment in North Carolina. And for that punishment, you can be fined up to $1,000, and your sentence can be 72 hours in the jail, up to 6 months in the jail. That is likely going to be suspended, and you'll have your choice now of doing 72 hours in the county jail or 72 hours of community service. If you choose the community service, you'll do the 72 hours of community service instead of 72 hours in jail. Now, having said all that, for those 3, I have had clients who just go to jail for 24 hours, 48 hours, or 72 hours rather than do the community service. If your sentence is suspended and you're placed on probation, again, you're going to have to get the alcohol assessment and follow through with those recommendations, complete your community service, pay your fines. Now, you also have to pay for community service, and you have to pay for the assessment. Now, the next level down, 5, 4, 3, is level 2. And level 2, level 1, and level A1 is where you start to have to serve some part of an active sentence in jail if you're convicted of level 2, level 1, or level A1. So that's back again, you're trying to make sure you have more mitigating factors than aggravating or grossly aggravating so that you can stay in 3, 4, and 5 and not go to jail. Now, level 2 is usually done when there's a grossly aggravating factor that applies. So I went over the aggravating factors earlier of have a prior conviction within the last 7 years, have somebody under the age of 18 in the car with you, have a driving while license revoked at the time, foreign impaired driving, things of that nature. If any one of those grossly aggravating factors apply, other than having someone under the age of 18 in the car with you, if you have someone under the age of 18 in the car with you, you're jumping right down to level 1. But if if one of the other grossly aggravating factors apply, then you're going to be at a level 2. Level 2 is a fine of up to $2,000, a minimum jail of at least 7 days, and a maximum sentence of 12 months. So again, the important thing about a level 2 is even though the judge may give you the minimum sentence of 7 days, you're going to have to actually serve those 7 days in jail, even if it's your first offense. So be mindful of that. You're going to have to spend at least 7 days in jail. If your rest of your sentence of up to 12 months is suspended, then again, you're going to have to get an assessment, and you may even be ordered to wear an alcohol monitoring device. That's level 2. Level 1 for driving impaired punishment comes into effect when you have a minor child in the car with you at the time you were driving, or you have 2 of the other grossly aggravating factors. So if you only have one grossly aggravating factor, and that aggravating factor is that you have a minor child in the car, you're going to be forced to serve an active sentence. If there are 2 aggravating factors that are not a minor in the car, then your grossly aggravating factors that are not a minor in the car, then you're still going to have to serve an active sentence. You're going to be sentenced as a level 1, which is a minimum of 30 days, up to a maximum of 24 months or 2 years. So if you get into a level 1, you know you're going to have to serve a sentence of at least 30 days. And you could be sentenced to up to 24 months. Now, if your sentence is suspended, in other words, the judge, say, sentences you to 24 months, suspends all of it, but 30 days that you have to do active, and then they're going to place you on probation. Again, one of the things they can do is make you wear an alcohol monitoring ankle bracelet, basically, to make sure you're not drinking. And again, you're going to have to undergo substance abuse and follow through all those. But the key thing to remember in level 1 is that you're going to have to serve an active sentence of 30 days, even if it's your first offense. And then finally, the worst, absolutely worst level for you in North Carolina is level A1. That's an aggravated level 1 sentence. For that, if you have 3 or more grossly aggravating factors, let's say you had somebody under the age of 18. Let's say you had a prior DWI in the last 7 years. Let's say you were driving while your license was revoked for that prior DWI. Then you're going to be a level A1 for sentencing purposes. That's a fine of up to $10,000 and a sentence of 12 months to a maximum of 36 months or 3 years. And you're going to have to serve as a minimum of that 12-month sentence, 120 days active sentence. Then the rest of it may be suspended, but does not have to be. Whatever sentence you're getting, and you often will get the full 36 months if you're down at A1 with most judges. You're not eligible for parole during that time either, so you're going to serve the whole 36 months. So again, level 1 is if you have 3 grossly aggravating factors that apply to your case. So I know this is all very complicated because you got the issues of, what are the grossly aggravating factors? What are the aggravating factors? What are the mitigating factors? And when do they apply? You've got, okay, now that they apply, am I level 5, 4, 3, 2, 1, or A1? And if I am, what's the minimum sentence? What's the maximum sentence? What does the court have to give me? What can they choose to give me? It's all very complicated. So again, I highly recommend that you speak with an attorney if you're charged with driving while impaired in North Carolina. It's no joke. It's not anything to play with. You can also figure that depending on what level you're convicted of, you will spend just in fines and court costs and things anywhere from minimum of $750 to $1,000 to up to $10,000. And then, of course, consider your attorney's fees and all of that. And then maybe that'll help you make a better choice if you've been out drinking rather than drive home. We got a million choices now. We got cabs, we got friends, we got family, we got Uber, we got Lyft. Reach out to one of them and let them drive you home if you've been drinking. Now, for the secret I was going to tell you, or for the one danger point I was going to tell you about. So let's say you want to make sure if you're out having a few beers that even if you get caught and convicted of driving while impaired, what's the one thing you want to make sure you don't have apply to your case? Or what is the one thing that if you do have apply to your case, you're going to have to do an active sentence? Well, if you look through those grossly aggravating, and mitigating factors, there's one that stands out. If you have somebody under the age of 18 in the car with you when you're pulled over for driving while impaired, and then ultimately get convicted for that driving while impaired, you're going to have to serve an active sentence of 30 days, even if it's your first offense. So I like to tell people, think of it this way. Let's say you and your family, maybe with another family, y'all go out for pizza one night. And you're sitting around, you're having pizza, and you order a pitcher of beer, or you order a couple of beers, and you drink a couple of beers, and you got your wife there, and you got, one of your children there who's under the age of 18, maybe 9, 10, 12, 15, 17, doesn't matter. You've had a couple of beers, and you're driving home, and you get pulled over, and you've got that 17-year-old, 16, 10, 9, whatever age with you. If you get convicted, you're going to have to serve an active sentence. So when I tell people that when I'm at a party or out to dinner with folks, and I say, be careful, because I see you've got your child with you. If you get convicted going home tonight, you're going to have to serve an active sentence. And they're like, no, it's my first offense. And I'm like, doesn't matter. Even on your first offense, that's the one thing that if it applies to your case, you will have to serve an active sentence, having someone under the age of 18 in the car with you. So don't do it. That's even more reason not to take that chance. Even if you just had 1 or 2 beers at the pizza joint or at the restaurant or at the bowling alley or at the ball game or over at a friend's house, if you have your child with you, don't drive home. If your spouse or your friend isn't drinking, let them drive you home, or take an Uber, or take a Lyft, or find another way home. If you want to make sure that if this is your day that you get caught, that you don't want to go to jail for an active sentence, then you just don't want to have your child in the car with you. So that's a very basic overview of punishment for driving while impaired in North Carolina. It's a lot of moving parts, a lot of complicated things, a lot of factors to take into consideration, a lot of arguments to be made to a court. That's why, particularly if it's your second or third driving while impaired, you need to probably hire an attorney to represent you. Now, the other thing you need to be aware of is whether you're convicted of A1, 1, 2, 3, 4, or 5, you will lose your license for at least a year. So even if you're convicted of the least level for you, a level 5, you're going to lose your license for a year, which means you can't drive. You can get a limited privilege if you apply for it and you're eligible for it. That would allow you to drive to and from work and allow you to drive for educational purposes, some other minor purposes. But you got to apply for that. It's not automatic. So again, you're talking about high costs and fines. You're talking about super jumping your insurance rates. You're talking about, at the very least, not having a license for a year, or if you get a license, it's for limited purposes. You're talking about possibly going to jail. So again, just don't do it. Find another way home. If you do it and you do get caught and you do get charged, go see an attorney, hire an attorney. So that's it for today's lesson. If you ever have any questions about it, you can call my law firm, Probst Law Firm, at 336-721-9090, or find us on Facebook, Probst Law Firm, or on the internet with our web, probstlawfirm.com, or email me at bob@probstlawfirm.com. If you know of anybody who might enjoy this video, please like it and share it, and share it with anybody who might get something out of it. That's it for today. Everybody, like usual, stay safe and peace.